At the outset, I am thankful to the Ecostar business and his team, more particularly Mr. Uday Kumar and his team, for having invited me to this SME Conclave being conducted in this BSc International Hall. Friends, I feel it my fortune to be amidst you all to address this session. Friends, India has set up the goal of becoming the Vikasit Bharat in 2047, and SME being the major segment in India, it has a plentiful prospects and fortune in the days to come. And I feel if these SMEs are properly guided and they are made aware of the available funding resources and the government scheme and the government patronage, they will certainly feel enthused to set up their own organization and contribute to the cause of becoming Vikasit Bharat in 2047. With this brief background, I will now take you through my presentation. My presentation will enlighten you about why an incorporated entity, whether this partnership or LLPs can get converted and seek listing on the stock exchange, the SME IPO process. Then once you are listed on the SME IPO, you will be regulated by the LODR regulations 2015. What are the obligations you will be facing for that? And if you follow all those things, what is your future in the corporate India and to build this nation? This is what I will briefly try to take you through my presentation. Friends, if you can see the words I use for the SME, it is not small anymore. It is assuming tremendous importance in the emerging India and more importantly in the industrial productions and enhancing the productivity and utilizing the best of the resources and contributing to the growth of the country. That is what this SME is going to play in the near future. That's why I'm saying no small anymore. This is what these opportunities are available to you, and one must come forward, get themselves educated about the activities they can undertake through this mode of organization, and they can contribute for their future also and for building the nation as well for that. Friends, as this Ritesh Shah of the BSc told you earlier that they have a separate SME platform and how this funding requirement can be taken care of. That is a brief introduction he has given to you for that. Friends, if you are expecting to become a successful SME, you must be guided by certain principles and build up your organizations. For you to become a successful SME, I will suggest and I will request you all to prefer an incorporated entity. I personally feel with the growing globalization, the world is more comfortable with dealing with an incorporated entity, with a legal entity, which has got the perpetual succession. The world will not prefer to deal with an individuals. That's why I strongly recommend that you must be a company formed and registered under the Companies Act 2013 or any act prior to this. Once you got incorporated and formed a company under the Companies Act, you will be coming under the umbrella of Companies Act 2013. This is a piece of legislation which has been passed by the Parliament to meet the present day requirements. The irrelevant and redundant provisions of the earlier acts have been completely removed, and this new piece of legislation has been adopted by the Parliament in 2013. Now it is, at present, it is operational in India. This new piece of regulations speaks about a lot of compliances to inculcate the habit of enhancing the corporate governance. Because the market forces look at you, how you are governed, how you are delivering to the investors, and how you can be acting as a protector of their capital. That is how these provisions have been accordingly incorporated in this Act. Once you are incorporated as a company, you will be subjected to these provisions of the Companies Act, which are briefly narrated. I will explain to you one by one. Once the company is incorporated, the ROC will issue a certificate of incorporation, and the both important documents is about the Memorandum of Association and Articles of Association, which are called the internationally as the chartered documents. These are very important documents for you to accordingly preserve, because this will form a basis for you while you will be undergoing the due diligence process before IPO. So these are the very important documents you will get from the ROC once the company is incorporated, and you must preserve them as the perpetual set of documents with you. That is very important for that. Then this new Act requires you that you must obtain a certificate to commence business. In the earlier Act, this was applicable to only public limited companies. Now this is applicable to private limited companies also, and under the Section 8 companies also for that. So what is the requirement under this? Under the 1956 Act, the subscriber to the memorandum were committing to bring the capital in a company. But unfortunately, that Act was silent as to how many days or period within which the subscribed amount has to be brought in. So to remove these things, the new Acts provide that within 180 days of the incorporation, you must bring in the subscribed capital and put it in a bank account. And with these things, you are required to file Form 20 Capital A, which will grant you the certificate of commencement of business. Prior to that, you can't do any business activities, even including any contractual obligations for that purpose. So these two things are primarily very important that you must look into for that purposes. Then once you are becoming company, you have to hold regular board meetings, general meetings as per the provisions of the Act. The law provides you that you must hold a minimum 4 board meetings with the intervals of not more than 120 days, and a general meeting which is called the annual general meeting once in a year. Then you are required to maintain certain statutory registers required under the Act. That is register of members, register of share certificate, register of duplicate share certificate, register of related parties, director shareholding. All these registers are required to be maintained. Because why I'm making you through all these things? Because these documents are very much required while you go for a due diligence pre-IPO. Section 12 of the Companies Act, it speaks about the things which your later head of the company must bear with. It is the name as is incorporated under Certificate of Incorporation, the scene number, your address, your GST number, all this must be printed on a letterhead. If you fail to do all those things, and if you file a document with the register of companies, they may go through that. If they can notice any discrepancy from Section 12, they will issue a notice for non-compliance, and you will be required to face all the process of compounding, litigation, prosecution, all those things for that. So this Section 12 also has to be completely kept in mind, and beginning with the letterhead of the company, how it is to be accordingly prepared, what it must display, that is provided in the Act. Nowadays, the ROCs are very particular to issue notices under this section for that. Then the next thing is about the composition of the board of directors. The Act says for the unlisted companies, it should be 3 directors and maximum can be 15. You can go beyond 15 provided it passes special resolution under the general meeting for the purpose. This is a basic requirement that every company is following for the purpose, notwithstanding whether you are intending to become IPO listed company or otherwise. Besides, you need to appoint key managerial personnel. Key managerial personnel means a MD, whole-time director, CFO, Chief Financial Officer, and a company secretary. These 3 individuals, functionaries must have to be appointed in case your capital exceeds 10 crores rupees for that purpose. This is a mandatory requirement for that. Then, nextly, more important about the related party transaction. This Act, more importantly, regulates intercorporate investments, intercorporate loans, and related party transactions. What is related party transaction? One of the underlying principles is that whatever the related party transactions you are intending to enter into with a related party must be at an arm's length basis. So this is a principle you have to follow all through while entering into related party transactions. Again, the same principle, the non-compliance, or if you are careless in compliance with the related party transaction, at the time of due diligence, you will come across certain non-compliances and you will be forced to go for a compounding for the purpose. It will be a time-consuming process for that. So, you also need to take a proper compliance of the related party transactions, which is under Section 188 of the Companies Act. Next one is about the CSR compliances. The applicability of the CSR compliance is prescribed under Section 135, and if your profit exceeds 5 crores in a financial year, that provision is getting applicable to you, and 2% of the average of the last 3 immediate preceding financial years, that amount has to spend on the purposes and the objects mentioned in Schedule 7 to the Companies Act. In case you fail to comply and spend this money, you have to compulsorily transfer this amount to the Prime Minister Fund or to the Relief Fund or any other funds prescribed under Schedule 7 for that purposes. You can't spend it as per your wishes for that. And you have to make a necessary disclosure of spending the amounts under these forms CSR2 along with your director's report. These are the very stringent requirements stipulated by the Government of India. This is Parliament also. Then more importantly, the appointment of auditors is one of the very significant process you need to follow once the company is incorporated. The auditor has to be either statutory auditors who will be conducting your financial audit and will submit their audit report for yearly operations. Next is about the internal audit. There are certain thresholds are prescribed. Once you trigger those, you need to appoint an internal audit to conduct an internal audit of the company. And the next is about the secretarial audit. This is a new concept introduced under this 2013 Act. And under these things, if you are borrowing beyond 100 crores from a financial institution banks, these provisions of this section 204 will be applicable to you, and you will be compulsorily required to undergo secretarial audit for the purposes. Then, having done all those things, you have to do requisite filing with the ROC at a periodic intervals. There are certain event-based returns. There are filing of annual accounts and annual return with the ROC on completion of 30 days and 60 days of the annual general meeting. That is very important. And other, if you are making some KMP appointment, all these things, those MR1, all these things, those returns are also required to be filed for that purpose. And the required let-down procedure about this appointment has to be accordingly compulsorily followed by you. And more importantly, this is I am talking about the Companies Act. In a secretarial audit, there is one clause inserted in the certificate MR3 that the secretarial auditor is also required to verify the audit of the other laws applicable to a company. This is a very vast area which the secretarial auditor is supposed to undertake audit for the purposes. And if you are found non-compliant in this area, certainly you will be inviting the notices from the ROC, you will be required to undergo compounding, or you will be adjudicated by the competent authority prescribed under the Act. Friends, you must have recently come out with some things. Government of India issued recent notifications. The Code of Wages and the other labor laws have been notified by government in November 2025, and the rules are just notified maybe a week before, and these 4 wage codes are now applicable for it. With this application of these 4 labor codes,